This is Akube Ndoromo again. Beginning of the trial on March 26, 2007. Docket entry number 67, entry day November 30, 2007, page 4 and 5. The court, actually, I have money laundering, policy statement related to health care, the wire fraud. What we have done is kind of tracking the language of statute for the health care fraud and the policy statement related to health care matters. I don't know if you have something more comprehensive than that or not. I can show you both what we have. There wasn't anything really in the Red Book or the Federal Practice Book. Mr. Austin, I will get the court and the defense counsel something, probably right after the lunch break. I will be able to get something. Government robbery of 1.2 million from the banks and 800,000 from health department and the 2 vehicles, all belonging to Akube Ndoromo and the Voice of Social Concern. Number 1, key witness in Mr. Ndoromo's case, Deputy Chief of Healthcare Patricia Square cleared Mr. Ndoromo from healthcare fraud. Number 2, the expert witness working with the U.S. Department of Justice in Washington, D.C. cleared Mr. Ndoromo from policy statement, money laundering, and wire fraud. Number 3, the court found the prosecutor, Roy Austin Jr., committed forgery. Number 4, the indictment is different from evidence presented in the trial. Number 5, the verdict form is different from the indictment and from the evidence presented in the trial. Number 6, the petty juries were dismissed without voting to the verdict form. Number 7, Mr. Ndoromo was sitting outside the court seeing the juries taken to lunch. Few of them came back in less than 10 minutes and Mr. Ndoromo was called and locked up. That the jury found him guilty. The petitioner, as pro se, moves the Honorable Department of Justice Civil Rights Division for the United States of America, challenging District Court for the District of Columbia corruption and the ruling of June 18, 2008, denied Section 2255 in open court. The court, I will tell you in your face that Section 2255 is denied since you favor appeals court you filed to them to review your Section 2255. But that reaction was vindictive, and please see transcripts on June 18, 2008 in open court. The United States Court of Appeals for the District of Columbia Circuit filed on June 12, 2008 and was filed to District Court on June 13, and Mr. Ndoromo received it on June 18, 2008. In open court, the district court judge ruled on Section 2255, denying Section 2255. That lacks merits. Co-report Jakia Sullivan. Akube Ndoromo is petitioning the United States government for violations of robberies in bank accounts, shutting down businesses, and laid people out of jobs. The officials involved are ex-attorney General Kenneth Winston, ex-Attorney General Jeffrey Taylor, Prosecutor Roy Austin Jr., Prosecutor Ellen C. Epstein, Judge Imad G. Sullivan, Magistrate Judge John M. Pasola, etc., and the D.C. Circuit support of robberies in holding Akube Ndoromo unconstitutionally in custody for 51 months and shutting down his business for 14 years after robberies. See United States versus 455 and $2,703,000 in funds from Bank of America civil action number 102 036 RGS, Ndoromo versus United States of America. The court denied Mr. Ndoromo from defending himself. The court claimed that the law doesn't allow the defendant to present his evidence. The judge and the defense counsel were given something by the government. Even before Brady, the Supreme Court created duty for the prosecutor to disclose perjury testimony. Due process is violated any time perjured testimony is procured by the prosecutor. In Money versus Harlem and the Houghton versus United States, solicitation of perjury is not required even when the perjury comes completely on the whim of the witnesses of the prosecutor. If the prosecutor knows it is false, there is a duty to disclose it. Government and the court contend that Section 2255 was supposed to be filed after sentencing, but see Rule 1 of Title 28. Section 2255, 1 year period of limitation shall apply from the date on which judgment of conviction. Plus, even Mr. Ndoromo was sent to prison without being sentenced. The date on which the impediment to making a motion created by government action in violation of the Constitution or laws of the United States of America removed if the movement was prevented from making a motion by such government action, as like the one to Mr. Ndoromo was in custody under a wrong judgment of that court, and he was not even sentenced, who seeks immediate release at the time. The judgment violated the Constitution and the laws of the United States. The court lacked jurisdiction to enter the judgment or taking Akube Ndoromo to trial because he was the victim. See Smith versus United States. Because the petition has not timely filed his Section 2255 challenging within the applicable statute of limitation, the court denies the petitioner's motion for relief. Government failed to answer Section 2255, see docket entry number 89, dated May 9, 2008, and see the reply of Akube Ndoromo, docket entry number 92, entry date June 7, 2008. More still about the government's games that they play, robbing people, small businesses, special people, the immigrants, and they're using judge like Judge Imad Sullivan and the district psychot like a Court of Appeal, Chief Judge Santel to cover them up is yet to come. Thank you for watching this one.